All right, this is the case of the state against Kyle Rittenhouse, and appearing in the court are appearance.
The state appears by Assistant District Attorneys Thomas Binger and James Krause.
Good morning, Your Honor. Attorney Mark Richards, along with Natalie Wisco, appearing with Kyle Rittenhouse in person in the courtroom.
All right, and it's here today for some continued hearings and a Daubert hearing, and I did review the report of Dr. Black, and then over the weekend I had been checking periodically for a report by witness Willis, and couldn't find any, so I left a note for the clerk to contact Mr. Binger and see where the report was, and found out for the first time yesterday that there's no report. Do you want to comment on that?
Your Honor, as I indicated in my email, the state's position is that the jury does not need to hear from an expert to make a decision on the issue of self-defense here. The jury instructions are quite clear that it's what a reasonable person would feel is appropriate, and I think we'll have a jury of reasonable people. There is no scientific, technical, or other specialized knowledge that will assist the jury in making that determination. So it was not our intent to have an expert on the issue of self-defense or use of force here. However, when the defense informed us that they were retaining Dr. Black, we responded twofold. Number one was to file a motion challenging Dr. Black, which is what led us to today's hearing. But we also retained our own expert, Bob Willis, who has spent the last couple months reviewing voluminous documents and all of the video and photos in this case, is in the process of preparing his report. As I indicated to the court yesterday in my email, he should have it by October 18th, and we will get it to everyone at that time, assuming the court decides on the other motion that expert witness testimony will be allowed in this case. I think it's also helpful for the court to give us some guidance in what the scope of those opinions will be at trial. For example, at the last hearing, Your Honor indicated that Dr. Black would not be allowed to offer an opinion as to the ultimate issue here, whether or not the defendant's actions were legally justified, whether a reasonable person in his circumstance would use deadly force. And I think that that's a very appropriate decision by the court, but I also think it's helpful for our experts when he's working on his report to understand the parameters of what the court will allow. So I have communicated that to Mr. Willis, and he is going to take that into account when he's making his final opinion in the case. So I think that there are a couple of issues that need to be decided before we go any further. One is the motion that I've raised, which essentially argues that this is not something that either party should have an expert witness on, because the jury is well capable of making this decision on their own. And then second of all, as I said, maybe a little more guidance from the court as to the scope of the opinion that would be allowed to be offered by the experts. And as I said, I think the court has already indicated that the ultimate question is not one that the court will allow an expert opinion on. I don't know if the court intends to limit it any further than that, but certainly that sort of guidance will be helpful when we go forward.
Thank you. Did you want to respond, Mr.?
Your Honor, I thought we were both going to be here to kind of test each other's experts a little bit today. I'm willing to go first, and we have Dr. Black ready, and obviously getting a report 2 weeks before trial, depending on what is or is not allowed, is a bit late when we all had experts.
Actually, the minutes from the pretrial of May 21st state defense to disclose their expert witnesses by 8/1/21, this includes filing of any expert report. What did that mean to you?
That the defense would be doing that. And Your Honor, if you'll recall,
It didn't cover the state.
when we set these timelines, Your Honor, I did
Okay.
urge the court to give the parties a greater amount of time between that deadline and the trial date. I urged the court that 90 days was a very compressed time period for the states to respond to the defense expert by potentially filing a Daubert motion, retaining our own expert, et cetera. The court expressed confidence that we would be able to accomplish that all within that 90-day period. So that's where we're at today.
Well, but if you needed 90 days to address his, how come you're turning yours in on October 18th, which is 13 days before the trial?
I understand that, Your Honor.
Where did that date come from? I mean, where did that date come from?
My discussions with Mr. Willis. He indicated to me that he would be able to have it done by then. If the court would like it sooner, I can urge him to get it done quicker than that. But as I said, Your Honor, I did raise this short time period with the court when the court set these deadlines. I did urge the court to give us more time to get this accomplished because I was concerned that this compressed timeline would not give us a lot of leeway to get all this done. Well,
First off, on the subject of expert witness on the subjects that are discussed, I'm going to use Dr. Black's report as an example because it's the only one I have. And there are many points in there that I think are suitable for expert witness testimony. I've been trying cases for 50 years, either as prosecutor or judge, and I learned things in there, at least what he says is factual, that I never had considered before. So I definitely think there's much of value in terms of if it's supported, and I'll hear what you have to say on that, but that could be useful to the jury in reaching their verdict in the case. I even have given additional thought to the question of opinions on the ultimate fact, which are permissible under the law. What the thought I was attempting to convey, and I think actually was, well, what is the law, and what I think I conveyed was intended to convey was that as to what constitutes self-defense, that instruction will come from me. That's the law, and not from somebody else. But whether, when applying that, the evidence that Dr. Black or Mr. Willis, is it Dr. Willis or Mr. Willis?
Mr. Willis.
Mr. Willis. It may impart may be sufficient basis upon which to permit an opinion on the ultimate fact. I'll have to decide that down the line. But certainly in terms of defining what constitutes reasonable force, whether there's a self-defense, under what circumstances self-defense exists, those are legal issues that I'll have to tell the jury about. Shame on me for not pinning some guidelines on this, because I assume that this expert report from Mr. Willis will be coming more quickly than it is. We'll have to deal with that issue down the line. In terms of use of force, expert, and I was thinking about it, and you say there's no necessity for it, but unless my memory disturbs me, and I know it doesn't, your office has been using use of force experts. You used it in the Jacob Blake Shesky shooting, You used it in the shootings, there was an officer involved in a couple of shootings, and you used a use of force expert in that. Why would, if someone with the eminence of Mr. Gravely or Mr. Zaff would want that kind of evidence or report available in making a prosecutorial decision, why would it be inappropriate for this kind of evidence to be utilized by the jury?
Because there's a different standard for police officers than civilians.
Well, I agree with you there. Well, I don't want to say that. I don't want to say that. There may be, in certain instances. We'll have to apply that as the situation develops, in the evidence. But regardless of that, I mean, there was a lot of content in Dr. Black's report that would certainly be, and he recognized that in his report, would be applicable to the an ordinary citizen, particularly the ordinary citizen Rittenhouse. So
I think what the court is referring to is that there have been situations in which the district attorney has had to make a decision as to whether or not a police officer's use of deadly force was justified or not. That is the legal responsibility of the elected district attorney, such as Mike Gravely in the shooting of Jacob Blake by Rustin Shesky. The evaluation in that process considers the training, the protocols, the guidelines, the rules, the handbook that are set forth for Kenosha police officers, and how those were applied by that officer in that situation. So when I talk about a different standard, and I think Dr. Black's expertise is largely in this area of whether or not a police officer followed the training and the rules and the guidelines set forth by their department that govern use of force. We don't have that here. Mr. Rittenhouse is not a law enforcement officer. There are no guidelines or rules that he's expected to follow. He's an ordinary citizen. And so the basis for my motion was largely that, and I think the court has hit the distinction right on the head. If we had a jury that needed to be educated as to what the law enforcement agency's guidelines were, what is reasonable adherence to those guidelines, what may be considered excessive or a violation of those guidelines, Dr. Black would be one of those people that could tell the jury about that, at least for the law enforcement agencies he's familiar with in Oregon. But this is not that type of case. The jury doesn't need information about that. The jury is no different than anyone in terms of a reasonable person. These are going to be the people that we're going to bring in off the street, who are going to serve as jurors, who are representative of our community, and they will make a decision as to what a reasonable person should have done in Mr. Rittenhouse's situation. They are in as good of a position as Dr. Black or any expert to make that decision. They have all of the requisite knowledge they need. I understand the court's point about Dr. Black's report, and I see some information in there that can be developed by counsel on cross-examination. The stage can be set by witnesses in terms of the scene that night, the circumstances, the darkness, the fires, the ambient gunfire, things like that. That stage can be set through other witnesses, and then counsel can argue to the jury as to what effect that might have had on a reasonable person, such as a person in Mr. Rittenhouse's situation. But we don't need an expert to talk about those things because they're basically common sense. We're talking about nighttime being dark. We're talking about the effect of gunfire. We're talking about the effect of crowds. These are all common sense things that I think reasonable people can understand. And so I think the court's distinction is an important one because this is not those types of situations or examples the court mentioned. This is not where we're talking about a law enforcement officer's compliance with the procedures set forth by their department. So that's why I think the examples you mentioned, Judge, are not applicable to this case. And I would further indicate that there have been other cases in this court and others, and I would turn the court's attention to a Mark Carver case a couple of years ago. The court may recall that was a case in which there was a road rage incident, and the defendant got upset with another driver, went over and confronted that driver with a knife, and stabbed the other driver. The other driver was unarmed. The other driver had punched Mr. Carver prior to the stabbing. This court didn't even allow a self-defense instruction in that case. And this court obviously didn't allow an expert witness either, because those were things that could easily be understood by a jury. Judge Wagner had a similar case.
Wait a minute. If I didn't allow a self-defense instruction...
You're right. I misspoke there. You're right. But my point is that there weren't factual circumstances there that would have necessitated a self-defense instruction in that case. Judge Wagner recently had a case, Timothy Carson, which was a case in which a Bradford student had stabbed another student in a classroom, an unarmed student. And the court held hearings in that case and ultimately decided no expert witness testimony would be necessary there either, because the jury was capable of understanding self-defense concepts without any scientific, technical, or other specialized knowledge. So I think when you're talking about the examples you set forth...
Let me just say, I interrupt you for a second. When I was practicing law, and I would sit there at that very table, well, actually, most of these prosecutors sat on that side, but, and judges would make rulings, and I'd be sitting there and thinking, where is this guy coming from? I think that's clearly either, admissible or not admissible. And then I got up here, and even for a period of years, my mind did not change on that. But it gradually sunk in what I had been taught long before. The judge has enormous discretion on evidence. I don't think most lawyers have an appreciation of that. I think a lot of lawyers, it's a black and white. It's either is admissible or it's not. There's huge areas where there's enormous discretion. So what Judge Wagner did in a particular case, whose facts I have no knowledge, is absolutely no precedent for me. And in fact, I'll tell you one more story, and of course, I've always got a story. When I first, this is part of my learning process that I was just mentioning, I went to one of my judicial education programs, and there was another judge there from west part of the state, and he talked about a case that he had tried and how he had made an evidentiary ruling on a particular point, and he was appealed, and he was reversed on other grounds, but he was upheld on the particular evidentiary ruling in question. Because he was reversed on other issues, it came back for trial, and the second time around, he said the exact same evidentiary issue, and he ruled the other way. He said, I looked at it differently, and I decided to make the opposite ruling from what I made the first time. He was appealed and affirmed on that, too. So that's a judge who made two totally inconsistent rulings, which were within the spread of his discretion, and was affirmed on both of them. So that's illustrative of the judge's discretion on these things. And as I say, as what Judge Wagner may have decided in another case with whose facts I'm not familiar. Number one, I'm not familiar with the facts, and number two, Judge Wagner and I could be sitting up here next to each other, and we'd talk about it, and she'd go one way and I'd go another. So I get what you're saying, but go ahead.
I'm finished, Your Honor. Thank you.
All right, Mr.
Your Honor, the court, I wrote down, I don't have the institutional knowledge that maybe Mr. Binger has about all the Kenosha County cases, but the one thing I wrote down is they have no precedential value. The court said that. These under, the expert under 90702 is going to be decided by this court, which has great discretion in what it allows and doesn't. The most recent case from the Wisconsin Supreme Court was State v. Dobbs. That case was, I think, different than this case because in that the expert didn't apply facts of the case to what he wanted to testify, and it was excluded on those grounds. The standard is very low. Will it aid the trier of fact in the determinations at hand? And I believe that Dr. Black is qualified. We can put on that offer of proof. We have his CV and his report and the facts that we wish to elicit regarding it. I believe that under the circumstances of this case, it would have a great aid to the trier of fact. The state is ready to rebut or attempt to rebut whatever Dr. Black says with their expert who was recently named. But when Dr. Black testifies, he will testify that he did this evaluation not from a law enforcement standpoint, but the citizen standpoint. And that was one thing when I engaged him. I didn't want a bunch of law enforcement mumbo jumbo. I wanted things to look at the eyes of a 17-year-old in a very chaotic evening on August 25th in Kenosha, and that's what I think he can bring to bear on this case.
Thank you. All right. Well, I am going to open the door to the testimony of Mr. Black, or Dr. Black, rather, after I hear the presentation by the state, and then also to that of Mr. Willis when I have more information about that, and we'll see what can come in and what can't. So that's one issue. There was an issue you raised in an email yesterday about microphones on the table, and I will tell you that I believe that the media, I know that the media has been told they have to get their audio feed from the audio system here in the court. Does that make sense to you guys? Okay. So no additional microphones will be permitted anywhere in the courtroom. If anybody's taking videos out there or recording, that's not permitted under the court rules. So please, you must refrain from doing that, other than the 3 cameras here and the 2 stills over there. And there actually are a variety of good reasons for the rule, which I'm not going to get into. You had also had you had an issue about witness anonymity. Well, actually, beyond that, well, go ahead.
Your Honor, the court is well aware that there's a lot of attention on this case, and some of that attention is of the harassing or even threatening variety. The court has made some rulings in the past with regard to that. We understand that this is a public case. We understand that there's a right to confrontation. We understand that witnesses' names are going to have to be disclosed publicly. We understand all of that. Counsel and I have had some private discussions regarding the exchange of addresses of witnesses. I think we are in agreement that, generally speaking, addresses are going to be kept between the parties. We haven't put them on publicly filed witness lists because of that concern. But I think all the addresses that are needed among the parties have already been distributed. The concern that has been raised by some of the folks that we've talked to who are witnesses in this case is that their images, their photos, their face would be shown on TV, pictures would be taken of them and published, et cetera. And that has its own level of intrusion and concern in terms of safety and threats and harassment and things like that. I understand that this is not a common request, but this is also not a common case. Most trials that I've done in this courtroom, before Your Honor, nobody in the gallery has been here or even paying attention, so it's never been a problem. But this is a case in which there's obviously a lot of attention. So on behalf of some of the witnesses that I've talked to, I informed them that I would raise this issue with the court, that I would express that concern, and I would see if there's a way that with certain folks we can place a limit on photographs or video taken, or somehow arrange it so that their images are not shown publicly to the outside world. I understand folks sitting in the gallery will see them. That's something we can't control. But being broadcast over TV or video or published in the paper, things like that, there may be a couple of witnesses that are very uncomfortable with that, and I wanted to raise it with the court on their behalf. And obviously, the concern I have is for their safety, and I just don't want to put anybody at risk. So I want to raise that for discussion with the court.
Mr. Richards?
Your Honor, I don't have a position really one way or the other. The media is trying to do its job. I just want the people to be here to testify so my client can get a fair trial. I'm always afraid when people talk about amorphous threats and things like that. You know, I don't know who Mr. Binger's talking to or who's making these requests. I know that many of the people who are listed as witnesses have incredible social media presence that they put out there and put themselves out there as a witness. One of the individuals, I won't name him because of what we're dealing with here in the court, you know, he announced he'd been served with a subpoena, was looking forward to testifying and other things. He put that out under one of his names. You know, we're monitoring social media. And so I don't know where these threats are coming from. I don't know who's receiving them. So I really don't know how to respond. I just want to have a trial. I don't want people to be masked, you know, or covered up. What the court rules in regards to the media, that's above my pay grade.
Thanks. I would tell you that to the extent that I have any authority over this at all, and I'm not sure how much I would have, that would be very case specific. It would have to be witness specific, particular person, and the level of discomfort that the witness may have is, if it's relevant at all, it is only marginally relevant, because that's not the test. If there's a legitimate security issue, that may require some degree of scrutiny, and and my experience has been, and although this case is probably the most publicized case I've ever had, I'm not at all clear that it's the I could list quite a few cases that I've had and other judges have had here that I would say the tension level would be higher. This case happened to get into a political, we've talked about it before, and it got hyped up. I'm not trying to minimize the importance of the case, and certainly it's definitely important to all the people involved. But in terms of the degree of attention it's gotten, I do think that some of that is due to no, they wouldn't have occurred in ordinary circumstances, but it happened in a very tense period otherwise. And I certainly understand that there's some degree of fear that people have. As I pointed out in my letter, however, on the subject of the questionnaires, from my estimation, based upon my years in the courts, and I think many of my colleagues would agree with me, there are other cases that come in here where there is much more reason for concern, particularly for people who are residents of a neighborhood where most of the witnesses may come from, that is under control of various criminal elements. Not control is the wrong word, at least in Kenosha, but where there's really a scary situation for people, and that needs to be addressed. And in my experience, the media has been pretty responsible. I've never had a problem, and I don't go to the media and say, you know, can you do this, can you do that, in terms of censoring, but generally discussing some of the issues that you are mentioning. I have experienced great cooperation over the years. So I'm certainly not going to make any overture to anybody about covering this case any differently from any other. But that occasion could arise, in which case you should bring it to my attention, and we'll talk about it then.
Thank you.
All right, now, let's see, what was next? There were a few other things before we start the Daubert.
I think one of the things that's kind of hanging out there is a brief regarding the possession of the firearm by a 17-year-old.
I knew there was something. And yes, I worked on this. Yeah, go ahead.
Mr. Sharafi's handling that.
Oh, okay. All right. This is your motion, Mr. Sharafi, so you can be heard.
Thanks, Judge, if you can hear me. So I don't have a whole lot to add to the motion. I have read the response filed by the state in Mr. Black's case. And in reviewing it, what we're asking is the court just do a review of 94806 sub 3 sub C.
Do I have to? That's a very difficult statute to work with.
It is. However, I think it's easy to cut through this portion of it. The first part applies to people who are armed with a short-barreled rifle or shotgun. I don't think anybody's making that allegation. So, Your Honor, our position is sub 3 sub C, as it states in the plain language, applies only to a person under age 18 if that person is not in compliance with 29304 and, not or, and 29593. I would submit to you, Your Honor, that when you read 29304, it is the name of the statute is restrictions on hunting and use of firearms. So it's not simply a hunting statute, as Mr. Binger has set forth in his motion. It is also on restrictions on possession of a firearm by persons under 16 years. By definition, Mr. Rittenhouse at the time does not qualify under that statute. This statute does not apply to him. He was 17 at the time. And sub A of each portion of that subsection. So for example, 29304 1A is a prohibition on hunting. He's right on that. But 29 sub 1 sub B is a restriction on actually the possession of the firearm. And that is true for sub 2, which talks about persons 12 to 14 years old. Sub 2 sub B is restrictions on possession of a firearm for a person 12 to 14. And sub 3 of that 3 sub B is restrictions on possession or control of a firearm for persons 14 to 16. There is nothing in 29304 which would be a prohibition on a 17-year-old possessing a firearm. Nothing. He cannot, it is impossible. And the way that the state is saying this is they're saying because he's 17, he can't be in compliance with that statute. So what that means is this, to take this to Mr. Binger's final conclusion, a 13-year-old can possess a firearm under this statute. There are ways they can do that. A 13-year-old can possess a firearm if they're in the accompaniment of an 18-year-old. But under no circumstances would a 17-year-old be able to possess a firearm. That makes zero sense. That the legislature would write a statute that allows a 12-year-old to have a gun, a 13-year-old to have a gun, but a 17-year-old can't have a gun. It makes zero sense. So what we believe is
why would they have the general proscription of the law in 2A that says any person under 18 who possesses or grows armed with a dangerous weapon is guilty of a misdemeanor if your interpretation is sound?
Well, if, 3A, Your Honor, talks about who it doesn't apply to, right? So it doesn't apply, yeah.
Well, the exception, as you're looking at it, swallows the rule of 2A. Now, the legislature does, there was a point, it's got to be 20 years ago now, when on the same day they passed two conflicting pieces of legislation. So they got a busy job up there, and they have, they get into sessions where they're passing laws. Speaker Pelosi talked about, well, we'll read it, and this is Congress, of course, but we'll read it after we pass it. And that seems to be sometimes the attitude when you've got two conflicting statutes passed on the same day. But I was looking at the rules of construction again last night, and Sub A, I think, sets forth the general policy of the law that a person under the age of 18 with limited exceptions, which are not so well stated in Sub 3, is not to be out and about with a dangerous weapon. Go ahead, I interrupted you.
No, I agree. I disagree with this, Judge. I don't think that Sub 2A is swallowed by the exceptions. And the reason I say that is a 13-year-old who is walking the streets is guilty, period. They are guilty because they don't fit within one of the exceptions of 29304, period. They do not. So it doesn't swallow the rule. Each one of those Sub 1, Sub 2, and Sub 3 are all age specific up to 16, and they all set forth restrictions on people not hunting only, but hunting and then simply possessing a firearm. So I disagree that it swallows the rule. There are clearly situations in which no 12-year-old can have a gun, Judge, period. That's what the statute says. Why would they put the word
18 up there then? Why did they put in the word, why did they say 18?
Well, I don't know. I'm not positive I can answer that question either.
Oh.
But what it appears to be from a plain language of 3C is the section only applies if you're under 18, have a short barreled shotgun, or rifle, which he doesn't, and are under the age of 16, according to 29304. He doesn't. He doesn't fit under that statute. And it is not simply a hunting statute. It is a restrictions on possession of a firearm statute. So I can't see it because his age is not mentioned. It is not mentioned anywhere in 29304. There is no subsection of that which applies to him. None. So I understand it's not a well-written statute, but there appears to be exceptions for 17-year-olds. And that's what he was at the time. There is nothing limiting restrictions on possession of possession or control of a firearm under 29304, which is an exception to Sub 2 Sub A, which the court has talked about. So from a plain reading of it, it doesn't, he's not in violation of that statute. If he was 16 or under, he could be. But because he's 17, he cannot be. That's our argument.
Thank you, Mr. Binger.
I think what the defense is missing here is that Chapter 29 of our Wisconsin state statutes is entitled Wild Animals and Plants, and every subchapter deals with hunting, trapping, fishing, commercial activities, fees, education, game wardens, etc. That chapter sets forth many of the rules and regulations that apply to hunting and fishing in the state of Wisconsin, which is something that is a proud tradition of many Wisconsin residents and is a very substantial industry in our state. The Wisconsin legislature, when they drafted 948.60, established a blanket prohibition that if you're under the age of 18, you can't be running around with a gun. That's the general rule. And what we have in this case is clearly a 17-year-old running around with a dangerous weapon. This case is a perfect example of why we don't want that happening, because 2 people died. Now, in recognition of our strong industry of hunting and fishing and trapping, etc., there were some exceptions carved out, and those exceptions are set forth under sub 3A, B, and C. I think those should be construed narrowly. I think the court is right that those exceptions are not intended to swallow the rule, and the defense interpretation of sub 3C would rewrite the law to say that if you're under the age of 17, you can't possess a dangerous weapon. But that's not what it says. It says 18. The defense interpretation would allow any 17-year-old to run anywhere in our community, our state, with a dangerous weapon. That's clearly not what the statute allows. Counsel says the defendant can't comply with 29.304. Well, none of us in the room can. It doesn't apply to us. So he's not violating it. He is in compliance with it. It doesn't apply to him. However, 29.593 does. 29.593 sets forth requirements for a certificate to be allowed to hunt. Now, at trial, the state will put forth evidence that the defendant was 17 on August 25th, 2020, and had a dangerous weapon. If the defense, in their case, wants to establish that one of these exceptions applies as an affirmative defense to that charge, they can submit evidence that the defendant had a certificate to hunt and that he was engaged in legal hunting activities on the streets of Kenosha that night. I don't think they're going to be able to do that. But that's the way this would play out. And I could see a circumstance in which maybe in a more rural community, that might be a situation where a 17-year-old is running around hunting and they're charged, but then they establish compliance with these other statutes. And that may be a debate in that case. It's not going to be one in this case. The defendant wasn't hunting deer, he wasn't hunting turkey, he wasn't hunting wild game. He didn't have any certificate or training to do so. He was not in compliance with the hunting statutes, which are set forth in Chapter 29. So, Your Honor, the defense interpretation here, as the court has rightly pointed out, would swallow the entire statute. It would establish a precedent that 17-year-olds can run around with guns, which is clearly not what the legislature wants. It's clearly not what the law says here. And so the count in the complaint that charges the defendant with possession of a firearm under the age of 18 is an appropriate criminal charge against the defendant. I believe the evidence will show he's guilty, and I don't think the defense will be able to establish that any of these exceptions apply.
Well, this would not be, if the purpose of the legislation was to neuter the statute itself, it wouldn't be the first time the legislature did that either. They sometimes do pass exceptions that swallow the rule for whatever reason, either by design or by oversight, and if legislation gets passed without knowledge of what's in there, that it would be easy to do exactly that. I'm going to deny the motion for now, but I'm going to. That's no guarantee I won't re-examine this. I just don't. I don't feel comfortable. It's a penal statute, and to hold people accountable for laws that, well, the basic rule, and there's plenty of interpretation on it, but the basic concept of the rule is that it has to be clear to ordinary people. And if you've got, judges spending hours here and hours or more at an appellate level trying to figure out exactly what the statute says, I mean, how does that serve the people? So I'm going to deny the motion subject to reconsideration. Without motion, I want to give more study to this. And believe me, it's not because I haven't looked at it extensively at this point. All right.
Would the court accept, we have some legislative history that I think either makes it better or makes it worse. Would the court, would the court be interested in looking at that?
I have looked at some, but if you've got something that perhaps I haven't seen, whatever, yeah.
I didn't want to get too far into a field.
Yeah, no.
We will provide it. And I'll obviously copy the state on it.
All right, but for now, it's tonight.
Understood.
All right, now, do we have anything else besides the Daubert?
I don't believe so.
All right, so go ahead, Mr. Richards. Go ahead.
Attorney Richards would call John Black. He's appearing remotely.
All right, Dr. Black, would you raise your right hand, please? You solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Go ahead.
Can you go on their television?
It should be on there if you turn it on. I think. They didn't, you didn't know what?
Defense will call Dr. Black and ask that he be sworn. My understanding that we have a stipulation that Exhibit 1 is Dr. Black's preliminary report and the only report he's done up to this point with the state. That would be Exhibit 1, and that is, I want to get it right for the record, a 29-page report, and that the CV is Exhibit 2, and that, in fact, is a 43-page report.
That's correct. We have a stipulation.
Would you please state your name, spelling your last name for the record?
John Black, B-L-A-C-K.
And Dr. Black, in what state do you reside?
Oregon.
And you're currently appearing remotely via Zoom?
That is correct.
And you prepared a report in the matter of State versus Kyle Rittenhouse dated July 31st, 2021, which has been marked Exhibit 1, correct?
That is correct.
And you provided myself back in July of 2021 a 43-page CV regarding your qualifications, training, and expertise. Is that a fair statement?
Yes, it was an appendix to the opinion itself.
And Doctor, what education do you have after high school? Briefly.
Do you want both what we would call formal education and police education, or do you want them separately?
First, the formal education, sir.
Formal education, I have a bachelor's in just general science. I took that while serving in the military. After that, my master's was in counterterrorism. After that, I pursued a doctorate, first starting out in Walden University in the combination of cognitive science and public policy, how people move from a planning stage into a decision. I found out that that's a lot more problematic than it sounds when trying to study, because you have the cognitive scientists and you have that. So I then went over to Capella University into the School of Business, where they allowed me to pursue the same problem, just in a different environment. And that was, how do people make sense of information and then move it into decisions? I received my doctorate from Capella ultimately.
And when did you receive your doctorate?
I think the award was 2018, if I'm correct.
And what was your dissertation?
The dissertation specifically was critical thinking as applied to the use of visual information as it then precedes decision-making. Now,
What kind of real-world training do you have, either in police science or military?
Yeah, so in the state of Oregon, I went up and through the different academy commonly related to as the Department of Public Safety Standards and Training, all the way up to command level, executive level, leadership type training. During that entire time, I both taught and instructed and received anything that would normally be associated with a police officer in the state of Oregon for 23 years. Additionally, in the military, my background is primarily in special operations. I did 30 plus years in the military. I was on what they would call the dynamic side. I was on a Special Forces A team for many, many years. Did many different things that you would commonly relate to that. But in addition to that, I also did psychological operations, which again is how people think and influencing people. And I also did civil affairs, which is nation building and anything from different cultures to that, to include even training people in civilians in other countries about self-defense, police tactics, or these type of things. During the time, I also taught civilian academies, these type of things. Since then, and also in police, I've acted as a consultant instructor, but also personally attend training. I'm an advanced force science specialist as an analyst. I hold examiner certification by Input ACE, which is video forensic, to understand the use of video specifically. I use that in understanding my analysis on use of force. Cognitive interviewing, I mean, it's all my CV, but just that's a quick overview.
And I'm just trying to hit some of the highlights. Are you trained in the use of firearms and the proper handling of firearms?
Not only am I trained, anything up from what they would normally refer to as a pistol up to a long gun, and then even extended range weapons out to miles for artillery. I also am a certified instructor in the same.
And you mentioned that you are, and I'll probably say it wrong, ACE certified in video review?
Yeah, so Input ACE, which is a Occam Video Solutions, a type of proprietary software in the review of video, offers both what they call an operator level course, how to use their software, and an examiner level course, which is how to use it in understanding what you're looking at, content. And I'm certified, or I've received a certification at both the operator level and the examiner level. And the final one, which I still have another course to complete, is a metrological level, which is the idea of light boards, a bunch of technical stuff that I'm not going to go into. And I'm about halfway through on that.
Have you ever testified in a court of law in either state or federal court as an expert?
Multiple times.
Have you, I should have asked it the other way, but can you put a ballpark number on the amount of times you've testified in a courtroom?
Yeah, so the short answer is I've consulted about maybe 60 times on use of force type cases. Out of those, I've written opinions 32 times and testified 20, plus or minus a couple.
So many times you're engaged in a case where you don't end up testifying. Is that a fair way of characterizing that?
Yeah, I mean, I'll write an opinion, and a lot of times settling by mediation or arbitration, a settlement is reached, or it's dismissed after the opinion's rendered. And
you were engaged in this case by myself to review the actions of Kyle Rittenhouse, a citizen, on August 25th, 2020 in Kenosha, Wisconsin. Is that a fair statement?
Yes, sir.
And do you look at cases involving a citizen differently than a law enforcement officer?
To a degree, to the state's argument of being put forth, the idea that I look at a lot of things from a police perspective, meaning the laws, the standards, as already been described. That's absolutely true. But the thing that even precedes that is all cops are humans. And so the fact is, the first thing we have to look at when we're engaged in these types of analysis or reviews is how is the human being involved, especially with the affect of their perception, attention, training, put in all the different variables. How is the human interacting with the event that's unfolding in front of them? So I would argue that first and foremost, every person involved in a use of force event is first and foremost a person, and that the principles outlined, in my opinion, are primarily directed towards that. So that's the first part, even if I were to look at police. And then, as the state accurately describes, if there's another layer to apply against the analysis or the reasoning, such as police standards, those type of things, I would then apply those as well.
And When you reviewed this case, primarily you did it through police reports and review of videographic evidence?
Yes, that's correct. A lot of video evidence and breaking that down, and then whatever reports and evidence that were given to me. Yes.
Now, in discussing testimony, or strike that, in putting together your testimony, is there anything to consider when making opinions by videographic evidence?
Now, when you say being put forth my testimony, are you speaking to the opinion that I rendered?
Yes.
Okay. Yeah, I think one of the things that's highlighted is video is amazingly powerful. It gives us insight into a lot of things, but it also has limitations. And I've outlined that in the report, and I can use an example right now by what we're looking at. I see a screen right now with potentially the judge is just showing with his honor's just showing with a phone emblem, but everybody else has mostly pictures up. Every part of this stuff is in the same field of view. I can see everything behind Miss Howell as I can see everything directly in front of Miss Howell with the same degree of clarity. A person, a human being, cannot do that because they're in three-dimensional space. And so you have to begin to understand these things. The value, which I completely agree with, of video, and some of the times the misperceptions of what we're looking at as just a human, and that's just a simple example.
And does the video show, in this case, obviously the actions of Mr. Rittenhouse are paramount. Does the video show Mr. Rittenhouse's point of view?
Oh, no, there's no way any video can show a person's point of view. That only exists in the person's mind. And that's where, and just for example, looking at all the different angles of the video, right? At no time do we see what Kyle Rittenhouse was looking at. We see what the camera was looking at, the video is, but we don't see what he was looking at. And even if we did see what he was looking at, that doesn't mean that we can perceive what he was attending to, what made a difference to him, or what he then interpreted from what he attended to. Video is a very good way from a hindsight examination to begin to get an understanding, but video never portrays someone's attention or perception. It's incapable of doing that.
Now, directing your attention to your review of the video and the police reports and information that you relied on, does the circumstances of that evening play any effect or any part in your evaluation?
I would argue yes. I have to take that into consideration because it's context. In other words, as a use of force expert, as a person that analyzes these type of things, everything is sort of painted on the backdrop of context, a canvas, so to speak, to use a metaphor. And in that night, the decision-making that occurred on that evening and that night, the decision-making that occurred by both those people that interacted with Kyle Rittenhouse, as well as Kyle Rittenhouse himself, were on the backdrop of things like riots and crowds and cacophony and noise and all these other type of things preceding violence. All analysis should, or I would argue sound analysis, has to take in effect the context by which it is determined. Something we do here may not be the same thing in another culture and vice versa. So yes, it does have effect.
The fact that there was ongoing chaos or community unrest, that is something you would consider?
I would consider. I wouldn't say it would necessarily make one thing more reasonable or less reasonable than the other, but to not consider it, I think I would be doing an inadequate analysis.
Okay. Now, in your review of this matter, you did break down videographic evidence, correct?
Yes, I did.
Now, when you review things videographically for times, Is that just using a stopwatch to get the times between first shot, second, third, and fourth shot?
No, and there's two things about this specific case, and this is what I usually do on these. And in the past, I've done them informally, and now I do them formally with a certification. The first thing is video has the ability to be compressed. So even if I was counting frames, for example, 30 frames per second, if I counted 15 frames, I could assume that a half a second had occurred. But video can be compressed. It can be moved around a little bit. So one of the things I did with this case, which I do with other cases, is I also took and applied a piece of sound editing software. But just the short answer is the audio stream, which is uncompressed, is in there as well. And so I validated the timing of the shots by both the videographic information and the audio stream as when the percussion of that sound started down to the 100th of a second.
And using a frame per second calculation, why is that superior than just holding a stopwatch and clicking it off that way?
Oh, yeah. So I used to run track. I used to use stopwatches, and so it's an interesting question. The short answer is if you think about the stopwatch, it's a perfect reaction. My fault. It's a perfect example of reaction time. I'm waiting for a stimulus. Something's happening on the screen in front of me, and then when that stimulus happens, I transition it to push a button on the stopwatch. Well, that takes time. So by the time I look at the digital display or the analog display of the stopwatch, I've also added in my own reaction time to that as well. Now, arguably, I do that the same way when I look at video and audio, but the difference now is I can go back frame by frame and see a muzzle flash and look down at the recording and have an exact count. Nothing to do with reaction time. I can do that in 2 minutes, or I can do that in 2 seconds. It's still the same reading on the screen. So I would argue it's much more accurate. And by doing so, I can use a baseline, which gives me a better understanding of what's occurring.
And you broke down the sound and pictures or video for event number 1, which was the 4 shots in car source 3 with Mr. Rosenbaum, correct?
Yes, I did.
And those are contained, the times in your report?
Also correct.
And those times would be the first shot is 0?
Is that a question? Yeah, it's not the first time is 0. It's that what I do is I use the first shot as the starting point. So it has a value. I give it a value of 0.
Okay. So the first shot is 0. The second shot would have been 26 hundredths after the first shot. The third shot would have been 25 hundredths after the second shot, and the final or fourth shot would have been 23 hundredths after the third shot, for a total of 74 hundredths from shot 1 to 4. Is that a correct statement from your report?
Yes, sir, it is.
And
You're dropping out.
You reviewed that, and you've used scientifically accepted principles to reach those times?
Okay, sir, just for the accuracy of the court, you did drop out on part of your question. Could you ask the question again?
I did.
Yeah, I'm not
Okay.
from the court. I'm not getting any transmission. If you're hearing me,
Someone forgot to turn the mic on. I can't imagine who that would have been. Try your question again.
So you've reviewed that video and sound stream, and you can provide that opinion to a reasonable degree of scientific certainty based upon your certification as a ACE input operator.
that is correct.
And you also did that for event number 2, correct?
Also true.
And in event number 2, you used the same principles?
Yes, sir.
And in event number 2, shot 1 would have been the 0 beginning of the sequence.
Also correct?
Shot number 2 would have been 68 hundredths after shot number 1.
Correct?
Shot number 3 would have been 1.98 seconds after shot number 2.
Correct?
And shot number 4 would have been, I'm having a hard time reading my handwriting, 2.77 seconds after shot number 2. Is that a fair statement?
That's a fair statement. And I would also point out that we're rounding to some degree. So I would say that all of those measurements are, depending on how a person looks at a frame, I would say the reasonable degree of certainty is plus or minus a hundredth of a second.
For a total of, within the parameters of the test, 5.637 seconds, correct?
Correct.
And that is offered to a reasonable degree of scientific certainty?
Yes, sir, it is.
Now, in your report, you talk about hindsight bias and outcome bias, correct?
Yes, sir, I do.
Could you please give the court an example of hindsight and outcome bias?
Absolutely. So the first thing, just as a walking the walk and talking the talk and setting the context for the frame, is that I don't use the word bias as something bad. We all have biases. It's not a big deal. We just have to, what happens most of the time is we're just unaware of them. A lot of times a bias may save our life, so it's not a bad thing to have. So using that as a frame, hindsight bias is just the fact that when we see something, and it's why it's closely related to outcome bias, is that when we look backwards, hindsight, is that we're able to discern stuff that supposedly we would have known prior. And the easiest example I can give of that to the group listening would be, think about how many times after something occurs and you say, well, it was obvious we shouldn't have done that. Well, it was so obvious, and the people you're talking to are your friends, they're not idiots, then why did they choose that? Well, they chose it simply because at that time it wasn't obvious. Hindsight bias is that idea by looking backwards, we can point out the one thing, the obvious thing that we should have known differently. And we have to be very careful about that when we're determining what was reasonable, because a person in the middle of making the decision does not have the luxury of hindsight. They don't know what the future is going to be. They don't know if they would have done this, it may have turned out differently, or that kind of stuff. What they're dealing with is in the moment. So hindsight bias is a very critical thing that I warn and caution analysts and review to be aware of themselves that they may be putting it in. The other one that you mentioned was outcome bias. And outcome bias is a choice, both either conscious or subconscious, below the level of awareness, that we determine the value of something based on the way it turned out. So the old adage from a systems methodology is that a system process can create desirable outcomes and undesirable outcomes. Sometimes a really good process, one that's really efficient, can still end up with a bad outcome or an undesirable outcome. Sometimes a bad process can end up with a good outcome or a desirable outcome. If you concentrate on the outcome and then go backwards, you're also contributing to hindsight bias. So if we look at the way something turned out, and I'm going to apply this directly to use of force. In lethal events and use of force where life has been taken, expired, the one given is that it's always a tragedy. The outcome is not something that we wanted, so to speak, society in general. But that doesn't necessarily mean that what led up to it or what didn't lead up to anything else. And if we look at only the outcome and we go backwards, that's also problematic, much the same way hindsight is. So an outcome bias, it's a concentration on the outcome as determining the value of the system as a whole.
When you reviewed this case, did you form an opinion as to whether or not Kyle handled his firearm in a proper manner during incident 1?
Not so much during incident 1. The video didn't really show enough clarity of handling characteristics. There was lead up to that where he had his weapon slung, and everybody has different tactics about what is proper or not. If we just consider handling in a safe manner, his weapon was pointed down most of the time and these type of things. He didn't seem to be reckless with his weapon in any way for the stuff leading up to event 1. And event 1, just for clarification of the court, we're referring to basically the gas station, correct?
We've kind of referred to it as Car Source 3. It's at, we would agree, at 63rd and Sheridan. So we're all on the same page.
Yes, sir.
And now, going in to event 1, were there any environmental factors that came into play at that time?
Oh, I would argue yes. I mean, if you think about it, one, you have the actual act of, I mean, just think about the nature of the dynamic, and I'll use environment in a broad context, not just temperature and light and that kind of stuff. The first one is he's obviously, well, not obviously, but it would appear that he is moving away from somebody to be pursued. There's an object being thrown at him, which means he is the defender, or he is in a reactionary mode. He's trying to gain distance. We have low light situations. We have a crowd. We have a large amount of noise. We have a bunch of people filming. We have differentiations in light. You have it lit up more where they're going to and not as lit on the street. So all those things affect things like vision, your hearing, your ability to process a stimulus. Yeah, so the short answer is yes.
And you used the term he was reacting. Could you describe that more?
Yeah, the idea of reaction is the most simple way to do it is something else is being observed, is pushing, is doing something. It's acting as a stimulus. And then you're not the initiator of your action. You're playing catch up to their side of the equation, so to speak. This is commonly referred to in different things as, you know, an OODA loop: observe, orient, decide, act. And it's also referred in infrastructure in the same type of decision methodology: sense, anticipate, act, learn. I mean, it really doesn't matter. But the idea is something else outside of you is the initiator of the action, which means that the action you're doing is a reaction. You're reacting to their stimulus, that variable, or something similar.
And the acting force in event number 1, would that be Mr. Rosenbaum?
Again, I can't speak for the mind of Kyle Rittenhouse, but I would think it would be absolutely expected or reasonable that that would be the causal action, because up until that point, he was not moving in that area. So.
And in your evaluation of the things that happened in event number 1 at Car Source 3, what factor, if any, does the concept of novel situation play a part?
Yeah, again, that's so when people are exposed to something that they've seen before, a driving event, you've been to the range and you've gotten your concealed carry license as a citizen, whatever it may be, the more that you get exposed to something, it is not as novel, and you begin to build basically ways that you react to it. And we're just going to call those heuristics. They're sort of like subroutines. You don't think about them a lot. You don't think about how you hold the fork or how you drink a cup of coffee anymore. You just reach for the coffee and the drink. You don't do it until all of a sudden, when you drink that cup of coffee, you put salt in it instead of sugar by accident. And all of a sudden you realize what you're drinking isn't what you're supposed to be drinking. And now all of a sudden you realize your subroutine isn't working. It becomes, for lack of a better term, novel. The first time you've been exposed to it or something highly unexpected. when you're in that area, you don't have a library of choices to pick from because your library hasn't been filled up with the metaphor of those books. So you're creating your choices and your actions on the fly. You may have expected something, but all of a sudden it goes that. And many people have been in those situations, avoidance of a car accident. All of a sudden you're swimming in water and it's way too cold and you realize you're being pulled out. It's a tough place to make decisions at because it can be overwhelming.
In this novel situation, assuming this is the first time Kyle Rittenhouse had ever been chased by somebody in this situation, is one of the choices flight?
Oh, absolutely. Yeah, you can.
And did you see evidence of flight on the part of Mr. Rittenhouse?
Again, flight would be a subjective term. I see evidence of Kyle Rittenhouse moving away from what would be perceived as his adversary. And
do you see his I'll use your terminology, adversary do any physical actions towards him?
There is indication in the video that there's a closing of distance, and the closing of distance is occurring in a narrowing of space of movement, the space between cars and this kind of stuff. So the thing is, we have this idea of getting close, and I don't have a lot of room to maneuver. And then also the idea that if we're that close and we're being pursued, we're now bringing a weapon, a lethal weapon, into this. And that is Kyle's weapon, because if he doesn't retain that, that can be a lethal weapon on either side. And so those actions are all, I think, reasonably portrayed within the video and the evidence.
And when you say he wanted to retain that, what do you mean?
Yeah, and I can't speak for Kyle Rittenhouse. I don't know whether he wanted to retain it or not, but I would argue that that a person that has a weapon, such as a firearm, that one of the things that you want to do is to maintain control over it for two reasons. One, so that you're not unsafe to others. You don't inadvertently pull the trigger when you shunt or trip or do something with it. And the other thing is that you don't give a weapon, so to speak. You have your weapon taken away, and then it is now used on yourself or others. One of the common things you see, just a sling carrier with holsters for pistols, is they are a form of retention, some better than others, some not so much. But when they use the word retention, retention speaks to, does that person maintain control of their weapon?
And to your training, understanding, would it be reasonable for a person to want to retain their firearm from another person who has threatened to kill them in the past?
Yes.
Why?
Because if their firearm is taken away from them, and if they believe that person to be willing to do them serious bodily harm or anything else, a reasonable perception would be, once they take that firearm, they're going to potentially use it against me.
And in your report, you talk about motive and action. One of the key words that you use is the word means, correct?
Yeah, so I don't necessarily talk about motive, but I think what you're referring to is intent, means, and opportunity as a way of helping to give a framework for understanding use of force decisions.
Okay, and would you comment on means as it applies to the event number one? What would be the means?
Well, yeah, so the short answer of that intent, means, and opportunity in a really quick synopsis is, means is the tool, whether it could be a fist, a knife, a gun, or whatever. Opportunity is the ability to use that tool. For example, if you had a knife, but you were 100 feet away behind a closed door, you'd have a means, but you won't have opportunity. And an intent is a demonstration of the willingness or their intent to actually apply the means with the opportunity. If any one of those are missing, then it sort of doesn't work. So in this case, the means would be the fact that there was a weapon on scene, Mr. Rittenhouse's, but also the means exist on the adversarial side in that the means are fists, a willingness to engage in physical confrontation, any of these type of things that if Mr. Rittenhouse perceived that, that would be means that would have nothing to do with him. And again, we haven't had any comment on that yet.
And opportunity, how does it apply in event number one?
Well, it's a critical
Closeness.
No,
Go ahead.
and you just hit on it. The fact is, I have in the first couple of moments, the frames, we see the pursuit across the parking lot. And at that point, we have I'm not going to estimate the distance. I haven't done any mineralogical studies on it. I don't think it's that critical at the moment. But what we see is a closing of the distance. And so the closer and closer we get, where we get into the space of physical confrontation, the criticality comes down to now the lethal firearm, Kyle Rittenhouse's firearm, is now a potential weapon for both parties, not just something Mr. Rittenhouse would use either lawfully or unlawfully. But the idea is, in this case, when we get closer and we get into this potential range of the wrestling match, so to speak, where I'm one hand's distance away or 1.5 steps, so to speak, now that lethal weapon is part of both sides of the equation.
And after the fourth shot is fired in the area of Mr. Rosenbaum, you see on the video, because I'm trying to move this along, Mr. Rittenhouse continue, run around the car and come back to the site where another individual is giving Mr. Rosenbaum aid.
Yes.
And you see Mr. Rittenhouse make a phone call and then begin to run down the direction of Sheridan Road or to Sheridan Road and then in a northerly direction. Is that a first statement?
Yes, and again, the concept of run is subjective, but he was, whatever term we want to give, jogging, moving faster than a walk, but yes.
Okay, and that's kind of the events, the running down Sheridan Road is what leads us to event number 2. Is that a first statement?
Well, yeah, but it's two sides of the equation. The running, it places him in Sheridan Road, but it's the fact that there's a crowd and he's in this crowd and that you have two sides of the equation, the crowd and him. So the running puts him in a location, but running itself didn't cause the event, I would say, other than maybe the fact that he was paused in his running when he stumbled.
Okay. And you see a crowd gathering or coming towards surrounding Mr. Rittenhouse. Is that a first statement in the videos?
I think that's fair.
And there's some physical contact made by Mr. Rosen, by individuals, and Mr. Rittenhouse goes down on the ground, correct?
Yes, that's correct.
And between event number 1 and him being knocked or tripped to the ground, do you see him handling his firearm?
Yes, and just a clarification of the past one, we see a stumble and a fall. I don't want to imply necessarily that he was knocked to the ground, but at the point of the handling, he had maintained his weapon and he's on the ground with his weapon, which is a long gun, or often referred to as a rifle or firearm.
As he's going down Sheridan Road, is he recklessly pointing his firearm at people he thinks may or may not be a threat? Is there any evidence of that?
Not that I've seen on any of the video that's been given to me. In fact, I think he only looks over his shoulder, if I remember correctly, maybe one time. His focus seems to be on moving forward in his direction of travel.
Okay, and when he does that, that's the individual who runs up to him and films him and says, "Hey, did you just shoot somebody?"
Yes, and it's in that direction. Even when he got back up after the event, he still went off in the same direction that he was initially depicted in moving towards.
Okay. Now, when he's on the ground, does Mr. Rittenhouse immediately open fire on anybody who's around him?
Not depicted by the video evidence I saw.
Okay. Does he point his firearm at individuals who might be near to him without firing?
I say it's pointed in the direction. I mean, he's surrounded by 360. If his firearm is up greater than 10 inches off the surface of the pavement, it'd be pointing the direction of somebody. So yeah, the short answer is he does point it in the direction of. I mean, it's a firearm. The bullet travels long distances depending on the ammo, and so the thing is, he does that without firing initially.
Okay. And you can see some people react to the firearm without him firing and backing off, correct?
That's correct.
And describe what starts the shooting in event number 2, to your professional opinion.
Well, you've got a couple things going on, but I think the easiest way to describe it is if you were to think of a small circle drawn around Kyle Rittenhouse of some distance, whatever it may be, you've got layers of the crowd out there, and then what happens is someone is inside of that circle and moving towards him, and basically it makes contact with him physically and knocks him off balance. Now, what he was trying to do is up to him to tell the court or not. But the idea is, it seems like he was sitting up. He's getting stable position. And we know later on that he got up and tried to move again towards where the police were. So the first thing is someone coming in from the outside, using physical force to knock him off balance. And I would say that's where it first starts.
And when someone approaches him and they place their foot on Kyle's face, some would say that's kicking him in the face, correct?
Yeah. And remember, in that event too, if you look at the dynamics of that person had momentum as well. It wasn't just, I stood there and I pushed someone with a foot. One can, just by the very nature of, in this case, the adversaries, and we'll call this person adversary number 2, his 1 foot, it's a jump. Both feet are up in the air, which would indicate that there is some sort of momentum being involved in this as well. So,
and that individual is wearing what would commonly be referred to as heavy work boots?
I think that's fair.
And that in and of itself could cause a fatality, correct?
It's possible. I mean, a kick to the head, if applied with enough force, can cause damage that could be potentially fatal. I'm not a medical expert. I can speak to it from martial arts knowledge and reviewing homicides. The fact is, physical force applied to the head area can be fatal, or at a minimum cause loss of vision, blindness, hearing, breaking of the orbital. I mean, I'm not going to speak to the medical part. I'll just speak from my knowledge personally, that I know that being kicked to the head can cause severe damage, serious physical injury, and is a potential to cause death, yes.
And in event number 2, adversary, you refer to him as 2, but I refer to him as Jump Kick Man. That's the first person that Kyle shoots at after Mr. Rosenbaum, correct?
Yes.
And after Jump Kick Man makes contact with Kyle, what happens to Kyle, according to your review?
Well, he's I mean, there's a bunch of things, but the short answer is he gets attacked again.
Okay, and attacked by hands or attacked by an object?
Object. Basically, another person now has entered in the fray, and I've served on mobile response teams, and I've done other stuff, and I've been in other nations, Bosnia and everything else, and I've watched crowd dynamics at play. It's not uncommon that, you know, once something starts, it begins to escalate. And so now you were saying,
I didn't mean to cut you off. Go ahead.
Okay.
I didn't
So
mean to
now
cut you
what
off.
you see is this progression. So the progression isn't necessarily unexpected. One person's tried it, and now we have another person coming in with a skateboard, and they use a skateboard as a weapon against Mr. Rittenhouse.
And to your viewing, striking him where?
Head neck area. I wasn't able to determine if it was, you know, like above the neck and only to the head or down there, but I'd say the head or neck area is a good general assumption from the video.
And after this individual strikes Mr. Rittenhouse with his skateboard, he does what?
He continues to stay engaged with him. So this wasn't just a run by and, you know, this isn't like running through the sprinklers and getting wet and then coming back out. This person is, after he does the first, we'll call it a strike with the skateboard, you know, hard wooden, you know, I mean, think about getting swung out with a bat. But the fact is, he's taking his body weight with both knees and staying on Mr. Rittenhouse. Now, I think that's interesting because this would be indicative of him or an assailant as a way of establishing control. Whether you're a student of ground fighting, whether you've been trained in a civilian police academy, whether you've been trained in anything, the idea of putting knees down on somebody to use it as a way to potentially pin them or control them are techniques that are commonly taught.
And as he places his knees on Mr. Rittenhouse's chest, does he do anything with the hand that doesn't contain the skateboard?
Well, he's, yeah, and this is the ongoing part. So we have a strike. We have a attempt to control. And so the question is, what's the goal of this? Well, you can see that in the video that the left hand of the assailant is now beginning to go the body line. It's beginning to drop below the body line. And so the question is, what's down there and why would his hand do that? And my argument would be is if that hand is down there, that hand is potentially going for the weapon, going for the firearm. Now, can I say that with absolute certainty? Of course not. I can't speak of the mind of the assailant. Can I say with reasonable certainty, and that it would be reasonable if Kyle Rittenhouse had perceived that? Would I say that that's a reasonable perception? Yes.
And when this individual goes for the firearm, is there a reaction on the part of Mr. Rittenhouse?
Well, eventually, there's a struggle. I mean, the fact is, you can see in the multiple frames, this Mr. Rittenhouse is holding on to his weapon to maintain control of that weapon. It's being pulled because you can see the motion of assailant number 2 going away. He's not going into Mr. Rittenhouse. He's going away, and when he's going away, he's got his hand specifically on the weapon itself, and so he's pulling the weapon. And when he's pulling the weapon, at some point, obviously, approximately 0.684, the response is that Kyle Rittenhouse fires. So
in your review, just so it's clear, in your review of the video, you can see initially the hand going down below the body, and at that point you're not willing to say he's grabbing the gun. But in later frames, you see the assailant exercising force on the firearm, trying to remove it from Mr. Rittenhouse's person. Is that a fair statement?
No, it's absolutely fair. And so the thing is, on the first question, I can't know. On the second question, how did his hand get to the gun, which we do know, it's in the evidence, it's sitting right there in front of us. It had to occur between the time of the struggle and the time of when the second assailant has gone back to standing. So again, with reasonable certainty, like I said, could we assume, even though his hand was out of view, that he was getting control of the weapon? Well, yeah, because how else would his hand be on the weapon in the next frame?
And this all happens very fast.
Oh, yeah. I mean, amazingly fast.
And how many times, with your review, does Kyle Rittenhouse shoot assailant number 3?
If I'm making sure that I'm counting your assailants correctly, that would be 2.
The gentleman with the skateboard.
2 times.
How many times?
You're saying shot?
How many times does Kyle Rittenhouse shoot from your review, the individual with the skateboard, not jump kick man?
No, with the skateboard 1 time.
Okay. And that individual goes off to one side to move this along. Is that a fair statement?
Yes.
And in your review of the video, does there come a time where he's approached by, in event number 2, a third individual, assailant
Yes.
number 3? Describe that.
Yeah, that's an interesting one. This is, at least as depicted by video evidence, and other interviews as well, the only person that's actually going up now that has a firearm. This person has a pistol, and that makes a difference. And then the other thing that's sort of happening about that is there's really a difference in the movement pattern of this one, because at this point, after Mr. Rittenhouse had disengaged from, if I'm making sure with your count, we'll call him skateboard man, just to make sure we're not using numbers. If he had disengaged from skateboard man, we now have a third person in event 2 approaching and coming up on him. And that's, for lack of a better term, interesting. Go ahead.
And that individual has a firearm in his hand, correct?
Yes.
Describe the interaction between Mr. Rittenhouse and assailant number 3.
Yeah, there's a lot of stuff going on in here, and one in particular is we've got the approach. So the first thing is assailant number 3 closes distance. Now, we talked earlier about context. He closes distance with someone that has been wrestling over a firearm, and up to this point had discharged his weapon multiple times, that we would argue that assailant number 3 would have been aware of this. They've seen the idea. Now, at the same time, he hasn't sprayed the crowd. He hasn't done anything.
When you refer to he, I'm sorry to interrupt, but when you refer to he, who hasn't sprayed the crowd?
And absolutely correct. That's my fault. Kyle Rittenhouse has not taken his firearm and basically just pulled the trigger without any regard to anything and just sprayed the crowd, as a vernacular, to get back. But he has had very directed fire, deliberate choice in very specific context. The specific context would appear to be, I need to maintain control of my weapon. When the fighting of the weapon starts at, because even the attack itself is still the struggle over the weapon, ultimately. But what's funny, and I don't mean this in a demeaning way, what's odd, I guess would be a better term, is that the third assailant has his hands up we'll call it a universal symbol of either surrender or peace, or the fact that I'm not an aggressor. I mean, in fact, we still shake hands today to show we don't have a weapon in it. We still do these type of things. Even the military salute to some degree is based off of that history. And yet when I'm doing this, I still at some point, I being the third assailant, I change my movement pattern. And you can actually see it in the video where I load, which means I sort of, if anybody's ever sprinted or about to push something, like even push a door open when you came into the courtroom, you sort of brace off your back foot while you're loading up so you get better contact and better connection with the ground to apply your musculature through the door. You can actually see assailant number 3 load and go forward and re-engage. And you see that also not only by the loading of the foot, but the dropping of the torso and the shoulders. And so the thing is, this would be in direct contradiction to an expected behavior of someone doing something else other than moving in. And then ultimately with that one big, large step, when you see them stepping in, and don't forget the context, there's still people running around with wooden objects, potential things to hit people with and these type of things. And basically the third assailant ends up getting shot one time as that type of dynamic is occurring.
As he gets shot from the first position with his hands up to when he's shot in the arm, is he moving away from Kyle Rittenhouse or moving towards Kyle Rittenhouse?
I would argue that the evidence shows that he is moving towards. But again,
and that's where he struck once in the arm?
In the bicep, if I recollect correctly, yes.
And that's the last shot that Mr. Rittenhouse fires on August 25th of 2020?
Yes.
And Mr. Rittenhouse then gets up from his seated position?
Yes, at least as depicted in video.
And he begins heading down towards the police line on Sheridan Road?
Correct. He continues to head in the same direction that the beginning of the event started.
And in the videographic evidence, there's 3 more shots in quick succession?
Yes, and yeah, you can hear it on the soundtrack, but yes.
And does Kyle shoot at those shots, or the direction those shots are coming from?
Does Kyle can you rephrase that question, please?
Does Kyle take his firearm and fire in the direction that he perceives those shots coming from?
I don't know where Kyle perceived the shots to be coming from, but I don't see any indication that Kyle fired any shots based on that stimulus.
He does turn around shortly after the shots, correct?
Oh yeah, he turns around from the sound, but again, I don't see any indication that after he turned towards the sound, he also fired his weapon.
And then he runs towards the police line in the video with his hands up, correct?
Correct.
And you've reviewed this for whether or not Kyle's actions were reasonable under the self-defense law of Wisconsin?
That's correct, under the Wisconsin statute.
And do you have an opinion as to that, to a reasonable degree of scientific certainty?
I believe the actions comport with it, and that self-defense, as described in the standard, not speaking as a legal opinion, but I do believe that they were reasonably necessary.
I was doing event 1 first, Your Honor. Doctor, you understood that I was speaking of event 1?
I didn't, but using the same, using that as the question, I would say that the event 1 actions were objectively reasonable, and they comport with the idea of reasonable necessity under the Wisconsin statute, as I understand it.
And you've testified to the factors that go into that determination, correct?
Yes, sir.
And as to the shots fired in event number 2, is it your opinion to a reasonable degree of scientific certainty that those shots were also reasonable in the endeavor to try and protect Kyle Rittenhouse's person?
Yes, and speaking specifically, I would argue against the 3 assailants as the condition to that understanding, but yes.
And you refer to the 3 assailants. Does the fact that there are multiple assailants enter into your factors?
Oh, absolutely. And when I say 3 assailants, I just meant the assailants that made the choice to interact with Kyle Rittenhouse that evening.
And there were actually more than 3 potential assailants at event number 2. Is that a fair statement?
There were many people milling around. Their actions would indicate agitation, potential aggression. They were carrying things that could be used as weapons. They were obviously not pleased with what had occurred and were in a high state of emotion. I mean, that's depicted by just some of the soundtracks of that. So we have the actual assailants, those that chose to make contact to physically assault Mr. Rittenhouse. And then you have the potential, and that's what I was trying to describe when I described the different circles of those different layers. And those, it's very common in crowd dynamics. It's not an uncommon event.
When you say crowd dynamics, one of the labels of a crowd dynamic is mob mentality, correct?
It can be. It's not always there. I mean, we have peaceful protests every day. A lot of it is the what they are choosing to do, and but yeah, I mean, we talk about crowd dynamics. It's just the dynamics of the crowd. If we have mob mentality, can we have people pile on to something, or the anonymity, or their willingness to do stuff that they wouldn't normally be willing to do? That's more often attributed with, we'll call it the concept of mob mentality.
Thank you, Doctor. I have no further questions.
Yes, sir.
Let's break at this point, and I'm going to ask that you return at 1:20.
Your Honor, I have court this afternoon. I have a conflict.
Thought this would all finish in 2 hours' time?
I'm sorry?
You thought this would finish in 2 hours' time?
Where
do you have to go?
I thought we'd scheduled this for 2 hours, Your Honor.
I think you're right about that, but where do you have to go?
I have initial appearances this afternoon starting at 1 o'clock before Commissioner Keating.
No one else can handle those?
I can see if someone else in the office can.
Are you available this afternoon?
I'll make myself available, Your Honor.
Unless there's a specific case you want to cover over there.
No, I can see if someone else in the office can, Your Honor.
Okay, let's try to start at 1:20. I have a 1:15.
Can we make sure the witness is available? Dr. Black?
Yeah, good question. Doctor, are you available at, what is that? What is it? It was just
It would
after
be
10
11.
there, is that it?
Yeah, it would be 11:15 my time, Your Honor.
Are you available then?
And I will make myself available.
And Mr. Willis, will you be available? Where
Yes.
are you physically?
I'm in the state of West Virginia.
Okay, so you're at one little after 1 now. Are you available at 2:15?
Yes, I am.
Okay, great. Okay, 20 minutes after then.
How long does the court anticipate going this afternoon?
Till we're done.
Okay.
Okay, great.
Thank you.
Thank you.
Thank you.
And apologies to the court, confirming you're using the same Zoom login for this afternoon?
You're correct. You are correct.
Okay, thank you, Your Honor.
Thanks. Breaking till 1:15, 1:20 actually. 1:20.